Hey, estate planning attorney Paul Rabelais here, and in this video we're going to talk about what to do if you are the one handling an estate, perhaps as the executor, and someone contests the will. Okay, so sometimes it's part of life. Sometimes people contest the way an estate is being handled. So when you're the one handling it, what do you do when you receive information that someone's contesting something? And it's probably worth mentioning at this point that sometimes heirs just they blow a lot of smoke and they don't formally contest anything, but they kind of threaten to sue because they simply just don't like maybe what they're entitled to, not because they're contesting something would have actual merit in a courtroom. So, sometimes you'll hear heirs say, well, he said he wanted me to have his house, but the will clearly provides otherwise. Or maybe someone says, she told me she was going to name me as the executor, and nowhere in the will is that person's name anywhere near any of the executor appointments. So sometimes people just don't like stuff, and that's just kind of tough. They're not gonna hire lawyers. They're not gonna go through the expense and the burden of having to contest something when they know they're gonna be a loser. So I just wanted to mention that sometimes you see some of that. But sometimes people think that their arguments do have merit, and sometimes they do. And they are willing to cover the expenses involved in contesting an estate. So when that happens, what does an executor do? Well, it depends on what's being contested. So I'm going to give you 3 different scenarios of potential contests and what an executor should do about it. So the first one is where someone questions or challenges the validity of the will. They're saying that the will is invalid. And when they say the will is invalid, they can't just say the will's invalid because I said so. They have to have some reason under the law why the will may not be valid. So now you first thing you do is you take a quick glance at the actual will and see if it meets all of the formality requirements. And sometimes on its face you can determine whether it's a valid will. So does it say it's a will? Are all of the notary and witness requirements present? Is the language, sometimes called an attestation clause at the end, if that's required by your state, is all of that language in the will? So those are things you can look at on its face. There are some things about the validity of the will that you can't tell on its face if it's valid. So, if it required a notary and witnesses, were the notary and witnesses, present when the person signed the will? So that you can't tell on its face. Sometimes people question the capacity of the person who signed the will, the person whose will it is. Sometimes say the will's invalid because that person lacked the capacity to understand what they were doing. That also you can't tell on its face, although sometimes people's scribble scratch when they sign the will is indicative that something was wrong. But sometimes people do say grandma, she didn't know what she was doing. She was influenced into signing this, and she did not do it with a full understanding or the required understanding of what she was doing. So you can't really tell that on its face. So then you often have to go back and maybe question the notary and the witnesses who were present when grandma signed her will. Perhaps even talk to grandma's doctors who were her doctors at the time grandma signed the will. So those are some of the things that should be handled if someone questions the validity of the will. The second will contest sometimes we see is in the interpretation of the will. There's no question about whether the will is valid, but some of the language in that will, its interpretation, is being questioned. That's usually because it was poorly drafted. So maybe a will says, I leave my home to Janice, and the guy dies and he's got 3 homes, none of which is any more of his home than any of the other 2. What do you do there? Or I leave my car to Fred and the guy dies and he has, 2 big old trucks and an RV. What do you do there? Or I've seen it happen where in the very beginning of the will, a gentleman said something like, my children are Larry, Curly, and Moe. And he didn't mention the 4th child that he had in that explanation at the beginning of the will of his family members. And then in the will, he says, I leave my estate to my children equally. So does that mean just the 3 that he named as his children and not the one that he didn't name in the children paragraph? So whenever there's a question as to the interpretation of a will, a couple of things you got to do. You got to go back and see if there have been any kind of judicial decisions in the past where a circumstance might have been similar and what did a judge do about it. Maybe you look in the particular state statutes. Maybe that can give you some guidance. And maybe you look into the circumstances, surrounding why that will was written that way. Sometimes when you look at the circumstances, you can better understand what the testator intended. So that's all stuff that perhaps the executor should look into if the interpretation of the will is being questioned. And then a third type of will or estate contest is sometimes people argue about how the estate assets are being handled. And so now we've got to look at, are all of the estate funds being gathered into one or more estate accounts? We have to look at whether any sales of estate assets, often the executor sells the home, sells vehicles, sells other estate assets. Are those sales done done for fair market value, arm's length transaction, or is there any funny business going on there? And then also need to verify and make sure any kind of estate expenses, whether that's funeral expenses or expenses involved in the administration of estate assets, whether those can be, documented and substantiated. So you may want to, if you're the executor, you may want to go in and kind of beef up your records and your documentation to make sure all estate expenses are appropriate. And then, sometimes it's just the length of it, the delays involved are sometimes questions. So as an executor, you want to make sure you kind of keep things moving along timely, or is there some reason why there are excessive delays? So I'll be the first to mention, contested estates completely change the ballgame when it comes to settling an estate. So even though there is red tape in settling estates, because you're dealing with lawyers and you're dealing with heirs and you're dealing with financial institutions and their lawyers and you're dealing with title companies and you're dealing with judges and courthouses and courthouse employees, at least you can get things done when all of the parties are cooperative. But when you have either an uncooperative heir, I'm not going to sign anything because I don't like the way things are going. Or you have someone who formally contests some estate matter. I've hired a lawyer. We're suing so-and-so. We're filing this petition in the estate. Not sure which one's worse, because the uncooperative heir just stops an estate settlement in its tracks. And then you have to, executor typically has to kind of haul everybody into court for some judicial resolution. I don't know if that's worse, or when someone formally contests a matter, they lawyer up, they formally contest something. But at least when someone lawyers up and formally contests something, at least there's going to be, it may take a while, it may be expensive, but there's going to be a resolution of that matter so that things can continue. But when you have either of those, you're going to wind up with an estate that ends up with completely broken and irreparable relationships, and often with a significant portion of the estate going to none other than the legal system. So big picture, what should you do as an executor? I'd say, if you even sniff the fact that there may be some contest down the road, I'd say at the earliest practical moment in the estate settlement, get all the parties on board quickly and have real clear, open, transparent communication. And, if there are issues, bring them up and discuss them and see if you can come to a resolution of certain issues, if possible, before everybody, quite frankly, lawyers up and turns the whole estate settlement into a fiasco. Now, if that's not possible, because some people just are going to refuse to be cooperative, and maybe they do that because they are justified and maybe they aren't, then it's going to be the executor's job to understand the rules, gather the appropriate information that you need to support your position, follow the rules to the letter, even if to the extent it may be a little bit inconvenient. Just make sure you understand the rules and you follow the rules, and again, document what you need to document to support your position, depending upon the nature of the kind of potential contest that will take place. So that should give you some direction, you executors out there. Nipping it in the bud early is the best. Make sure you turn the gray like button into a blue like button, and if you haven't already subscribe and hit the notification bell. That'll make sure you don't miss anything as I keep producing, having a good time, keep producing these educational estate planning and estate administration videos. We'll see you next time.